Good afternoon to all colleagues in Nepal. My name is Tim Hodgson. I am the ICJ's legal advisor on economic and social rights. I lead our work globally on economic and social rights. And to that effect, I've also had the privilege of working with some colleagues in Nepal who also work on the realization of economic and social rights in Nepal. Now, I also just want to say from the beginning is that I'm in South Africa, in Johannesburg right now, and I'm a South African lawyer. And so I'm going to speak from the perspective of a South African lawyer to try and assist colleagues here in realizing the right to education. Education is obviously a very important right. It's a right which the South African courts have acknowledged is essential to the transformation of South African society and to social progress in the country. And the South African Constitution is accepted by courts to be geared towards transforming society, to change the status and the circumstances of people living in poverty and without adequate protection for their human dignity, and to try and ensure that rights like the right to education are respected, protected, promoted, and fulfilled. That requirement of states, including Nepal, to respect, protect, promote, fulfill the rights in the Bill of Rights and the rights in international human rights law, including in the International Covenant on Economic and Social Rights, is one that really is consistent. And I have seen myself Supreme Court judgments in Nepal where there are aspects of international law acknowledged, and these are really great judgments which we share with colleagues around the world, and they are progressive, and the court shows serious leadership in that respect in some instances, exercising its powers to give effective relief for violations of economic and social rights. Now, of course, speaking from a perspective of a country from the global south, we of course understand that the circumstances are difficult. So there are a lot of people living in poverty. There is a lot of inequality and discrimination in access to social services. And so the idea that socioeconomic rights needs to be realized is also coupled with an idea that although there are some immediate obligations, so obligations that states must fulfill immediately, as in right now, there are also others which the state will be able to fulfill progressively over time within their available resources. I want to pause here to say one thing. There are genuine cases in which the government can illustrate specifically that it doesn't have adequate resources to realize a particular social and economic right. But in my experience, surveying jurisprudence from across the world, there are very few cases litigated on economic and social rights where there's adequate evidence presented by the government, both on what it has budgeted for the right and how it's used that budget to actually prove that the problem in its failures to realize economic and social rights relate to resources. And there are, of course, also many different things that are required to realize economic and social rights, including the right to education, which don't rely on resources at all. There are also lots of instances in which it's just inadequate planning, inadequate systems. For example, and I know this is a problem in Nepal too, in South Africa, there's been consistent litigation in some of our more rural provinces about access to textbooks and learning materials. Now, the courts have come down really strongly and said, without a textbook for each subject in each grade, a child really doesn't have a chance to learn, and the teachers really don't have a chance to teach. And as a result, the courts have said that the government is under an immediate obligation to deliver those books. In fact, in our policies, the government policies, there is also clearly a right to those books. But when it comes to court, the state will argue that it's doing its best within its available resources and it cannot possibly deliver them. Now, here, when we're talking about resources, we aren't always talking about money. We're talking about systems for delivery. And one of the major problems with this argument is that when it repeats year after year at the start of an academic year, there's no way for the government to say, well, we didn't have resources this year and we didn't have a system to deliver the books. And then we didn't have resources in the next year. Because the state has an obligation to plan and to fix the problems and to improve. And even progressive realization means it must improve its delivery of textbooks and its delivery of education in general over time. And from one year to the next, we shouldn't be seeing the same problem. And when we are seeing the same problem, courts will more and more, and in South Africa they do, try and intervene. The other aspect of that type of intervention, and let me just talk about that because it's a very important thing. Judges are sometimes nowadays much more willing to accept the position in international law, which is that economic and social rights are justiciable, meaning they can be brought before a court. What is more difficult for judges is to determine what an effective remedy is, because without a remedy there can be no right. And in international law, as in South African law, people have a right to an effective remedy for the violation of their rights. So what you really need to be able to do as a judge and as a lawyer in crafting an argument before a judge is say to a judge, well, what do we want? We want the government to change its policy in respect to the charging of fees in public schools, in respect to the charging of in the delivery of textbooks. We want the court to supervise this order to make sure that the government delivers. We want to ensure that there is compensation for people whose rights have been violated. These are just some options which exist when it comes to the realization of the right to education, as with all other rights. Another important aspect, you'll recall I spoke about the obligations of the state to respect, protect, promote, and fulfill the right to education. So another obligation there is the obligation to protect. The obligation to protect includes a duty on states to effectively regulate the right to education. Now, in South Africa, this becomes a big problem, and it's becoming a bigger problem. And it's also true all over the African continent. Why? Because as our governments fail to provide public services, which they are legally obliged to do in terms of economic and social rights, there is also a private sector, a big commercial sector that is coming into our countries to try and charge fees for children to go to private schools in their desperation because they don't have access to public schools or because the conditions at public schools are not good enough. Now, this phenomenon, described as the commercialization of education, or alternatively the privatization of education, is a problem not because of the fact that international law completely bans the involvement of private actors in education, but because international law applies human rights standards irrespective of who is providing education. So firstly, it places an obligation on the government to provide education, and then it places an obligation on the government to effectively regulate private stakeholders in education. In many countries, although there is legislation or there are policies to regulate this, there are problems because private schools will tend to act like they are inside of a market and outside of the law. Now, they might be inside of a market and they might have created a market for education and there might be people who are willing to buy it, but they are certainly not outside of the law. So, for example, one prominent feature which emerges in instances in cases in Kenya and in Uganda and in South Africa, courts are asked to rule that the fees that are being charged by private schools are unfair and unaffordable. Now, the right to education includes a right to accessible education that is accessible to everyone without discrimination of any kind. And this also includes a right to affordable education. In South Africa, school fees are not charged to over 80% of learners because of the fact that the government acknowledges that children will simply not be able to go to school, which is compulsory and is a criminal offense to not be allowed. And if the government is charging fees, or if private actors are charging fees that are not affordable, then there's a regulatory question. Can the government be said to be effectively regulating the private actors in the education system if fees are exorbitant? And more you'll see courts are coming to the conclusion that the government has not even taken action to effectively regulate it, or if they have not enforced those regulations through monitoring and evaluation. And those then become violations of economic and social rights. I've seen that you will be discussing the relevant instruments in international law, which may help you in determining whether or not a private actor is acting in violation of the right to education. And there are also, fortunately for us, the 2019 Abidjan Principles, which bring together standards in an international law and try and provide courts and other actors, including government officials, with guidance about exactly what should and shouldn't and can and cannot be permissible in the context of private actor involvement in education. It's very important as commercialization increases that we make a clear statement all around the world to both governments and to companies who want to trade in education that education is fundamentally a right that is essential for social progress, and that nobody has the right to make education unaffordable and inaccessible or accessible in a discriminatory way. There are immediate obligations on the state to prevent discrimination in access to education and to ensure the affordability of education throughout the schooling career. This also has an effect on other economic and social rights, because when people don't get a good education, they can't get into tertiary education, they can't find good work, and so there's a spillover effect that happens in this regard. I'm interested to carry on talking to you about the right to education and about the role of courts in enforcing economic and social rights. What I can say is that it's happening all over the world. It's happening all over Africa in the examples that I've given. It's happening in Colombia, in Argentina, in Brazil. It's also happening in Asian courts, in India and in Pakistan and various other courts. There are even courts, even conservative courts in the European context and in North America, that acknowledge the critical importance of economic and social rights in general, and in particular the right to education. And judges in any country, including Nepal, will do well to look at comparative foreign jurisprudence and international law standards in their efforts to realize the right to education. I wish you well for the rest of your conversation. I thank my colleagues from ICJ Nepal, including Karuna, for providing me with this opportunity. I only wish that I could have been there, and I hope sometime to travel to your country to assist in promoting the enforcement and realization of economic and social rights through legal means. Thank you very much.